Hello, everyone. Thank you for being on today's webinar. Today, we're going to be discussing the presentation Smile for the Camera, Taking and Legally Using Photos. This presentation will discuss how your organization, the considerations your organization should take when it uses photos. And this presentation is part of the Pro Bono Partnership of Atlanta. Pro Bono Partnership of Atlanta uh, works to maximize the impact of pro bono engagement by connecting a network of attorneys with nonprofit organizations. Many of you on this webinar are already aware of the Pro Bono Partnership of Atlanta. On your screen is a set of the criteria for participation in the program. If you are not already part of the Pro Bono Partnership of Atlanta's offerings, you should please review this criteria and see if you are eligible and consider reaching out to the partnership. This presentation will provide general legal advice for your organizations that have specific questions about how the use of photos or the other legal issues impact your organization. Please consider reaching out to the Pro Bono Partnership of Atlanta for advice. As for me, I am an attorney at the law firm of Bryan Cave LLP. We are an 1,100 attorney law firm with 100 attorneys here in Atlanta. My practice focuses on intellectual property and technology issues involving copyright, patent, trademark, trade secret, and privacy issues. Some of you may have been part of my presentation back in May on copyright licensing, and copyrights will form a very small part of today's discussion. Copyrights protect expression rather than facts. An example is you can write a story about how the Braves lost last night 9-0 to the Padres, and that story would be completely protectable because it was your choice in how to present those facts, but the facts themselves of that loss are not copyrightable. The copyright, of course, applies to the right to restrict reproductions of a work that your own creative thought created, or here, with the focus of this presentation, photographed. And it's important to remember that copyright's not the only right implicated with photos. It's arguably one of the smaller ones. The right to privacy and similar related torts are far more important for discussion here. Now, let's start off with two photographs. The one on the left comes from Forsyth Park in Savannah, and the one on the right comes from Dragon Con in downtown Atlanta. In both photos, we have people being photographed off the street without having been asked first that they were being photographed. The inner lawyer in each of us may have this initial concern, well, can I use a photograph of other people without having their permission first? And let's go through the considerations that you should proceed through in evaluating whether it's appropriate to publish those photos. So the very first consideration, this is where copyright comes into play, who owns the photo? Do you have permission from that owner to use the photo? The next question is, where was the photo taken? Was it in public? Was it in private? It's very different to take a photo of a public place versus hopping over a fence and surreptitiously photographing a secure area. But perhaps the most important of the considerations on the slide is, how will the photo be used? Are you going to draw attention to people in a way that they would not have expected? Will you misrepresent the circumstances of the photo? Is there any risk that you are going to be exposing private information to a public audience? And then the last of these considerations is arguably the least legal, but the most foundational. Will the publishing the photo help your organization? Your organizations use photos for many different reasons. And if your use of the photo would not advance your organization's interests, whether from publicity, fundraising, or some other purpose, including because it might irritate somebody, then there may not be value in having that photo published. So these next two slides are going to elaborate and present these considerations in a slightly different way. So first, with authorship. In general, a copyright is owned by the person who created it. And here, the emphasis is on a photographer, and the same would apply to a videographer as well. The creator can subsequently sell his rights or license her rights to someone else. Now, there are rules of thumb. Again, these were on the two slides back and just articulated in a slightly different way. The right to privacy is reduced the more public the photo is in, the more public the subject of the photo. And the photos are more likely to be acceptable when they are not disclosing private facts. The most frequent example of a private fact would be if you are disclosing that somebody is engaged in something, say an affair, something else they shouldn't be engaged in, that they're otherwise trying to keep private in a public manner and drawing attention to them, what tabloids do. And of course, and this is where probably your organizations would have the greatest point of concern, you should not use a photo of someone to suggest an endorsement of your organization or some activity which they had no intent of endorsing. And that's called, under tort, would be a misappropriation of identity claim. And if any of you have seen the television show Friends, the character Joey was always trying to make it big, and he was in a photo shoot. He was very proud of the photo shoot, and then found out his photo was used to advertise that he had a sexually transmitted disease. This would be an example of misappropriation of identity. Now there, of course, he probably signed a release or something else in this fictional universe where he had no tort claim, but that's exactly the sort of thing you want to try to avoid. You don't want to use someone's photo in a way that they never could have anticipated, or for them to suggest an endorsement that they never intended. So let's go back to the photos. First, let's start with the Forsyth Park example. Let's assume, going back to those considerations, that you have permission to use the photo. So let's walk through the other considerations. Well, first, the photo's in a public place. So that leans in, these balancing considerations, that leans in favor that you can publish the photo in a newsletter, on your website, on social media, any way you want to use it. Of course, the next key consideration is how will you be using it? And if it's just to show a public place, for example, maybe your organization would have an event in that venue. You just want to identify and make people think this is where we're going to be. We're going to be by this fountain in this well-known location. Then it's probably fine. In fact, with this particular photo, it's hard to imagine an instance in which your use would not be justified. Perhaps if you were to zoom in on one of the people and use and suggest that they were endorsing your organization or endorsing some activity in a particular way, that's when you would run into trouble. But a generic use of the photo as is, it's very difficult to imagine a circumstance by which you would run into trouble. Now let's go to the next slide, the one from DragonCon. And again, we'll start off and assume that you've received permission. Here, you've taken a picture of a parade. It's in a public place, but again, people are even more at the forefront of this photo. So how will you be using it? It really should be no surprise to the people that they would be photographed if they were participating in a parade. And there are many ways that you could use this photo, but absent some changes or misrepresentations to the photo, you likely have the legal right to use the photo, assuming it advances your organization's interest to have a photo like this. The inner lawyers in each of us, though, we've heard about copyrights, we've heard about trademarks, and we look at this photo and we see that you have a Star Trek logo, you have a Star Wars costume, and you know that these are intellectual property rights of the companies that have them. Here, it's really incidental to the overall use. You aren't misappropriating that intellectual property associated with the Star Trek and Star Wars franchises for any purpose, and it's really just incidental to the overall photo. If it is even considered a copying, it probably would fall under fair use, which we will reserve for the end. And just as a warning now, we want to avoid fair use as the first line of defense and focus upon the other criteria before even thinking about fair use. And now, as we turn to the slide, recurring issues for nonprofits, we're going to walk through 4 scenarios which we believe are common for nonprofit organizations and what they encounter, and at the end we'll cover fair use and then open up for questions. So scenario 1 is ownership. Someone volunteers for your event and they photograph it. Does your organization own the photographs, or does the volunteer? And some of you may have heard of this. It's actually written into the copyright statute, works made for hire. It's this idea that if somebody is employed by your organization, or if they specifically contract to create photos for your organization, then your organization is actually considered the author of those photographs of the creative works that the individual has come up with. In the nonprofit context, that could apply to an executive director, other members of the staff. It is less likely to apply to a volunteer, and it is arguably a volunteer will not be able to avail themselves of a work made for hire, even if you have a contract on the front end. It's a little nebulous. That's one of those issues that you should reach out to the Pro Bono Partnership of Atlanta if you really do want photographs or some other creative work to fall within this doctrine. So because you are not going to be within work made for hire, you have some balancing considerations. On the one hand, you do not want to offend volunteers who are going out and photographing your events out of the goodness of their heart to help your organizations. On the other hand, you want to protect critical materials so that the organization can use them in the future for fundraising, to demonstrate what you've been doing, to otherwise promote the organization's activities. So the rule of thumb is to obtain authorization by the simplest means possible. Sometimes that can be a simple one-page release that a volunteer freely signs. A lot of times you may not be in that instance, and it can be as straightforward as a volunteer emails you photos. Hey, here are photos I took of the event, and you write back, do we have permission to post these to our Facebook page, to our website? The authorization of the photographer writing back saying, yes, you have my permission, is sufficient for most of your purposes, and certainly evidences the authorization that you would need to meet that first consideration of, do you have the author's permission to use the photographs? Scenario 2, photographing people. Now, a lot of organizations, you host events, and it's a great opportunity to photograph people, show them embracing what your organization is doing. However, does your organization need the permission of the subjects of the photos in order to use those photos? And in general, you can photograph a person, but again, it's how the image is used that raises questions. You need to consider whether the subject has a right to privacy in the situation, and consider whether the photo is going to be used to show endorsement, particularly whether it's going to be used to show endorsement that the subject of the photo may not have intended. Again, this goes back to those considerations at the very start of the presentation. Here are some solutions that I've seen organizations apply. Some will, on the front end, seek a written permission from everyone. And that's certainly a suitable approach, and the scope of your authorization to use the photos lines up with the scope of the written authorization that you obtain from each subject of the photos. Other organizations proceed more informally. They so frequently post photos that you can assume that if your photo is taken, it's going to be posted online. In fact, sometimes the photographer will go around and say, hey, may I please take your photo of the event, and because we're going to use it for whatever purpose. We're going to post it to the newsletter. We're going to put it online. And that informal authorization is sufficient. And of course, some simply take down. They essentially ask for forgiveness if there's a subsequent objection. And with these informal approaches are in general fine, particularly the asking at the point of photo, hey, look, this is how we're going to use it. The informal authorization is quite fine. What you should probably be aware of is the more informal your approach, the faster you should be willing to respond if there is an objection to the use of the photo and your willingness to take it down. Photos can help promote your organization, but if someone disapproves of the photo, the motivation to take the photos evaporates. The third scenario, photograph of another work. You know, there are, whether it's a magazine, whether it's a newspaper article, you see some graphic that is perfect. It captures a set of statistics in a particular way that is right in line with your organization's purpose. So you see it, you know that you don't have authorization just to take the photo and put it online, or you have some question about that, but it's so great that you want to take a photograph of it and immediately post it to Twitter, because that will capture everything. People can retweet it and send it out. So can you photograph that graphic and put it online? And the unfortunate answer is no. You cannot photograph someone else's creative expression and use it. That is the very essence of copyright infringement. Just because you've taken something from a print medium or some other medium and transferred it to photograph does not somehow make it any less of a copying of someone else's work. So unfortunately, you cannot proceed in that manner. Instead, you should proceed to seek the original author's permission. And this also ties into the fourth scenario, news coverage of an event. You know, you're thrilled. The agency has come in, they're covering your event, and they've even taken a fantastic photo of the work that you're doing. Because it's your event that they've photographed and written a story about, don't you have a right to use it? And again, the answer is no. The fact that you had an event is not copyrightable, but their choice of expression about the event is copyrightable. So the article and likely the photo are owned by the agency, and you should ask the agency for permission to reproduce those, or perhaps to share them in your newsletter through some other medium. As we stay on the slide for a moment, it's better to remain in the good graces of entities that buy ink by the barrel. Plus, there's a good chance that they probably will grant permission. Now, if they fail to grant permission, or if they charge you some sort of fee for republication, there's likely a reason. For example, the agency may have a contractual relationship with its photographer, may have a contractual relationship with its reporters, where it is limited in what it can freely allow others to reuse their work, particularly on the photographer side. And plus, if they are going to charge you for the reuse of that photo or article, then there's an even greater chance that they would come after you if you used it without authorization. So now we're back at the fair use discussion. Fair use is saved for last because it could very easily be an entire presentation in its own right. And if you find yourself relying on fair use, you're probably in bad shape and should definitely this is a circumstance where you should consider reaching out to the Pro Bono Partnership of Atlanta, because fair use should not be your first line of defense in determining whether you can use a photo or not. Fair use is always a case-by-case balancing test. The four statutory factors set forth here, are balanced against each other to determine whether, in spite of someone's owning a copyright, you are allowed to copy contrary to that expressed statutory right. So let's think back to the Star Wars, Star Trek photo at the very beginning. Yes, the studios have a right in those designs, but photographing their use is not for profit. It is a photograph of the overall scene. It really has little to do with the copyrights, and in fact, it will do nothing to diminish their commercial value. As a general rule, if you are reproducing entire work in a form largely equivalent to how it could be sold individually, or you're producing it in a form that's entirely similar to how the original author created it, then you're likely using another's copyright. And if you still think you have a fair use defense, I would encourage you to reach out to the Pro Bono Partnership of Atlanta for additional consideration and discussion. So thank you very much for letting me provide this presentation, and I'm opening the floor up to questions.
Okay, we have a question. The question is this: isn't permission given when the volunteer sends you a photo? They're referring back to the discussion of a volunteer emailing you their photos that they've taken. The individual says, say the volunteer takes the photo and puts them on a CD and sends it to you. Isn't the permission applied that you can use those photos?
It likely is. The question is, and this is that's a very good question, actually. A photographer takes photos and sends them to you by email, or I think in the question was by a CD. They put them on a CD. There is likely evidence of authorization there. It really depends on the factual circumstances, the relationship with the volunteer, whether you find from the communication that there is authorization to you to use the photos in the manner that you want to proceed, online, on a newsletter. It really depends, but yes, in that scenario, that could very well constitute the authorization to proceed. It's always ideal if they say, here are the photos I took, use them for anything that you want. But if other circumstances create that impression, that to a reasonable person, then yes, you can proceed in that manner.
Would it be safer to ask the person directly, is it okay if I use these photos? Do you recommend that they do that?
Yes, I think yes. If it is certainly appropriate, and it's arguably a best practice. You don't want to burden a volunteer, but it is a best practice to write back and say, "Hey, look, these are great photos. Thank you so much for taking them. I'm going to post them to the website or however else you want to use them. Is that okay?" I think that would be the ideal circumstance uh, to proceed with.
I think we have some folks posing, but my other question, I do have someone who made a comment that their family is in the Webcast photo that we posted.
Oh, well, small world. I believe this qualifies as a fair use of the photo. I always like that photo.
Great. We have another question. What's the best way to handle photos or videos of a large meeting or conference with 800 or 1,500 people there?
So the question pertains, what do you do when you have a large conference with a large number of attendees? And I think going through the considerations, when the critical question is, how are you going to use the photo? And most crowd shots aren't focusing on the individual. Most of these large conferences are public events where you're simply trying to relay how large the crowd was, trying to use that to convey the imprimatur of legitimacy, of strength to this particular activity. So most of the crowd shots are probably fine. Where you run into trouble is if your use alters the factual circumstance by which the initial photo was presented, by which you are, say, focusing in on one individual to suggest something contrary to what was intended, or perhaps trying to draw some negative inference on their character by isolating them in that photo. When you start to do things like those two examples, that's when you run into problems with large groups. But in general, a large group photo is one of the safer ways to proceed if you're just using it to represent what's going on with the event.
We have another question. Does anything differ if we use photos of a child or children who are participating in an activity in a public space?
Children. Oh yes, thank you. The question pertains: what happens if you're photographing children in a public space? How does the consideration change? Uh, this is in general, the public space is fine. There are some additional considerations with children that are jurisdiction specific, but in general, you're okay. I would caution you, though, however, that you have greater concern over your organization's purpose when you're photographing children. There are some parents who are very defensive about having photographs of their children taken and then posted online, and you're much more likely to have a quick negative reaction to that if it's done without authorization. Uh, so from that, just from the goodwill standpoint of your use of the photos, it is more likely to backfire. You may well be within your legal rights to do so, but the backlash that you could receive from a volunteer or could be one of your end clients may not be worth the hassle of posting a photo of a child without authorization.
Is the socioeconomic status of a person, for example, whether someone is homeless or indigent, considered private information? Would you be concerned about posting something and representing what that person is homeless or indigent?
The question is, would the financial status of the subject of the photograph, how would that influence the considerations? And it certainly could influence them. There is private information about socioeconomic status. And if someone is, say, a client of your organization and it's not clear that they are at some minimum income threshold to meet it, that is problematic, and that's probably a situation where to maintain a good relationship with your organization's client, you would want to ask for permission. When it comes to a homeless person on the street, uh, you have the same considerations. However, it's a much more public display of, of their financial status. And The private concerns that would come into play are not as apparent because, again, they are homeless displaying their financial status in a public way. And arguably, if you're photographing them, you're probably doing so in a way to draw attention to their plight. And it's not that good intentions save you, but that rather the use of the photo is not intended in any of the ways that would cause your organization problems. The question is about taking photographs of people receiving medical treatment, particularly in an international context, such as an international mission trip. Uh, the yes, I mean the same considerations certainly apply. Uh, you there are different ways that you can photograph people. You certainly can demonstrate a photograph of a healthcare provider providing treatment without necessarily identifying the subject of it. Uh, it is probably prudent to your organization to photograph or just to inform people at the point that the photographs are being taken that is your purpose. As with all informal forms of notification, that is imperfect and you should be inclined to respond quickly to take down if you're relying on an informal authorization to proceed. Um, it is on the international context, you're in this awkward situation where the odds are the recipients of the treatment may not necessarily see it, but you're also trying to be on the honor system here and be on the up and up, and it would probably be prudent as I think through, because the medical situation is actually quite an interesting context. Medical care is the provision of medical care. The particular symptoms are private acts, and you need to be very cautious because they are private acts, and you are publicizing the private acts. So for that reason, you should be cautious in proceeding. There's no reason you cannot proceed, uh, but you should be very cognizant of the factors that people are aware of that you're taking their photo, and be judicious in how you use the photos and what private facts you choose to display with dissemination of those photos. That may require a follow up if I butchered that.
A question I have in follow-up to that, John, is would it be a safer approach to be sure that patients cannot be identified?
Uh, and I'm not sure if the microphone captured that. Would it be a safer approach if the patient was not identified? And yes, if you cannot identify the patient from the photo, then yes, that's clearly not. You've significantly reduced the privacy right implicated by the photo, and therefore you've increased your ability to use the photo. Um, you don't universally need to exclude the patient's identity from the photo, but the more if you can identify the patient, then you also are associating the private medical treatment being afforded to that patient and risking its public disclosure without the patient's authorization.
So you should get that authorization.
You should get it if you can. The more that you are identifying the patient because of the private act that you're potentially publicly disclosing. Now, if you're just showing a row of people lined up in a group shot, like here's the great work that we did on this medical mission trip, that is fine. But if you're showing somebody receiving certain dental care and they may have a particular medical condition that would be revealed, that's where you start running into issues.
We have another question. Should permission to print or use photos on social media always be given?
No. The question. Yes, I'm sorry. I failed to repeat the question. Should permission to publish photos on social media always be written? And no. If you have an indicia, sorry, excuse me, if you have authorization, even if it is oral, that is acceptable. The problem with oral authorization is that someone can come back and say, no, I never gave my authorization. And the writing is really to protect you, not so much to give it any greater weight, the authorization. Um, so, yes, absolutely, the authorization can be oral. but it may not protect you as well if the person forgets providing that authorization.
Um, would it be appropriate or an example of fair use for the organization to use a photo from the internet to represent an event? For example, if you're holding a 5K run and you want to take a picture from the internet of another 5K run and use that on your website.
Oh, thank you. The question is, would it be an example of fair use to take a photo from another event and use that to apply it to your own event? Say an example of another 5K race when your organization is hosting its own 5K race. And that's probably not going to be an example of fair use for a couple of reasons. First, let's go back. If it's another event, it will you have to seek the author's permission from a photograph standpoint, and that's probably going to be the real hang up here. Do you have the author's permission to use the photo? If that other event, that other 5K, you have the permission of the photographer to use the photo, that's going to go a long way. Then the next point of the consideration that really would matter is, well, would you be misrepresenting a set of circumstances by showing the 5K? If you're just showing a generic set of runners running at, say, some local spot, or there's some other reason that you want to use this other organization's photo, then that's leaning in the direction of okay. If you're showing bibs from that race, which clearly identify that other organization's activities and creating an association between your organization and the photographed organization, then you start to run into problems, and you really do need the permission of the other organization. Um, it probably never really gets into the fair use context from that standpoint. We'd have to go through the other factors, and I'm happy to take a follow-up on that. Just sitting here right now, I'm having a difficult time lining that up with fair use, and I think you run into the original author's permission, and then are you creating a false association with the other organization? Um, but it's a good question. One thing that is maybe a benefit to your organizations, if you are pulling photos off the internet, there are utilities that let you view the license of the photo. Now that significantly reduces the universe of photos that you can pull down. But for example, the Bing search engine, I believe the Google one does as well, has something where it will search only for a Creative Commons license, which means you can download those photographs, those graphics, and use them in your works without any concern that you are infringing somebody else's rights in the materials.
This question relates to actions by employees. It asks, what options do employers have to restrict employees taking photos of individuals being served by the organization to use on their own social media? So can you stop your employees from using pictures of your clients for their own Facebook page or other social media outlets?
And that's a great question. Can you restrict your employees' use of photos that they have taken with the organization's clients? Can you restrict the employees' sharing of those photos, perhaps on their Facebook page or other social media? And absolutely, if you have an employment relationship with someone, you can restrict that sharing. On the flip side, though, that use of social media is exactly what some organizations want to encourage their employees to do. It raises the profile of the organization. It shows that that particular employee is really invested with the organization. It implies a relationship they've formed with the end individual. And as long as the other participant, well, it essentially would go through the same analysis of whether it's appropriate to post that photo online of the organization's activities in action. Uh, there's not necessarily a need to bar an employee from doing that outside the organization, but the organization would be well within its rights if it took a policy decision that employees should not be posting photos of end clients.
We have a question that's related to the one you mentioned before. I know you talked about Google and some other search engines that may allow you to find photos you can use online. The question is, are there businesses or organizations that offer free stock photos that you can use, for example, for marketing purposes?
Are there organizations that offer you stock photos that you can freely use for marketing purposes? Yes, there are. And in fact, a Google search will quickly identify those organizations and their libraries. Uh, Admittedly, some are better than others. You certainly have a service like Flickr, the Yahoo service, that many of their photos are freely downloadable, and others are not. Uh, the I believe, my recollection with Flickr, and certainly with the Bing engine, and I believe with Google as well, you have the ability to search in the front end. Does this image contain licensure material that says I can freely use it? And that's one way of doing it. You can, of course, also go to these websites that will be generated from a Google search that will let you, that their entire library of images are freely downloadable.
Is it a good idea to give credit to the photographer for a photo, and is there ever an obligation?
The question is it a good idea to attribute credit for a photograph to the photographer, and are you ever required to do that? Uh, and the short answer is it's a case by case determination. Um, some photographers do not want their name listed. It's probably a best practice, but it's ultimately a case by case determination whether you proceed. A lot of times, people, if you're serving a charitable purpose, there is no guarantee that somebody necessarily wants to see their name injected into that. But at the same time, too, some people are taking photos where they do want to receive credit, because sometimes they may have freely given you permission, but they don't like it when they see their photo resurface on another website for something that they hadn't intended. And sometimes that photography attribution line provides some discouragement to unauthorized copying. So it's case by case, probably a best practice as a default to do so. Um, but again, it's case by case, and I apologize. There are many different approaches to that answer, to that question. Thank you. I believe that's the last question, unless somebody else is typing. Okay, well, thank you for the opportunity to present. Again, this webinar is given in conjunction with the Pro Bono Partnership of Atlanta. If you have any follow-up questions, please reach out to the Pro Bono Partnership of Atlanta. Thank you for the opportunity to present, and hope you enjoy the rest of your days.